objective of this discussion is of the CRETAM advisory is to guide all the participants and all the importers which are presently availing the benefit of the certificate of origin, the free trade agreement which India has signed with various countries with regard to availing the exemptions on the basic custom duty with regard to the certificate when a country, where the exporting country fulfills the condition of certificate of origin, the notification which prescribes the minimum value addition which is to be formed, and apart from that, other conditions which needs to be formed when a exporting country obtains a certificate of origin from the exporting country, and the importer furnishes in its importing country that certificate details to the custom authorities before obtaining the clearance from the goods. So this was the principle which was earlier used before 21st of September 2020. So we will discuss that what is this rule all about? What is the comparison between pre and post implementation process? We will also discuss that why this has come, what was the reason behind of bringing this rules into the country. So if you see that presently the India has 10 free trade agreement and 6 preferential trade agreement, which includes presently Asian countries, Japan, Korea, Singapore, STARC countries, and others, South Asian free trade agreements. So these are the present in force country of origin which has been signed with these countries. Now, what is important is that why this CAROTAR has come. So in the finance bill, they introduced section 28DA in the custom acts, which stipulated a procedure for administrating a verification of country of origin. So what was happening was earlier there was certain disparity between the country of origin, and the exporter obtains the country of origin either fraudulently or it was actually not a correct document, and the importer was claiming the benefit of on basis that document. Although there were certain specific signatures that were stored into the investigating agency of India, of the customs, but these were the only document based upon which the exemption was required to be provided by the custom authorities to any importer. So if someone is obtaining the benefit of Asian Free Trade Agreement and importing from Thailand and producing the country of origin certificate which were obtained by the Thailand exporter from their country, then that was the only document based upon which the benefit was to be given by the custom authorities. So what happened with that certificate of origin? There were 2 landmark decisions which came. The first one was between the High Court of Delhi and Meenakshi Exports, and the second one was Bullion and Jewelry Association versus Union of India. In both these cases, the authorities challenged the country of origin certificate, and they denied the benefit of the exemption to the importer. So in both these judgments, the importer challenged that the law does not prescribe asking for any additional document to be maintained or even asked by the authorities. So and basis that the High Court ruling, the benefit was granted to the importer basis the country basis the certificate of origin only. So in order to curb from these challenges by the custom authorities, because they do not have by a statute the power to ask the details over and above to the certificate of origin, the government has brought this amendment in the law, and they brought the specific provision in the law, as well as they formed the rules to identify the SOPs, the standard operating procedure, which needs to be followed by every importer who are availing the benefit of country of origin and free trade agreement, and they are required to produce all these details to the custom authorities upon verification. So there are 2 ways, 2 process which these rules have prescribed. There is a specific details with regard to the certificate of origin which has been provided by the exporter, which needs to be furnished while filing the bill of entry, which was earlier not required. And apart from that, there are certain other details also which are very you can say over and above the country of origin certificate details, which are required to be prepared by the importer in advance, whether the verification will be done or not by the authorities. So from that point of view, today's agenda of discussion is mainly to the extent of what all details we are required to prepare, and how much these details can be asked from the exporting country. In various cases, the exporter are mainly the associated companies, so there is always a likelihood of providing the same. But in other cases wherein there are no associated companies, all these details are required to be provided by the third party, which are not at all related with the importer. So there we are finding a challenge in collating the information and validating whether that information which was provided by the exporter is correct or not, and even relying upon that what all additionally importer can obtain in all those cases. So what was the pre-implementation process was you were importing the goods, you were filing the bill of entry and producing a certificate of origin, and while filing you were just mentioning the notification number related to the country of origin, and you were clearing the goods basis the same. So this was a pre-implementation process. Now what is after the post-implementation process is you are importing the goods, you are filing the bill of entry with additional details of the origin, the country of origin, wherein you are filling the details related to what is the certificate number, all these details which are related to certificate. And apart from that, there are certain other details which are required to be electronically submitted in your while filing the bill of entry. And in case, even after submitting that basic information about the country of origin and the certificate, there can be an inquiry by the custom authorities asking over and above that what all, and that verification, on that verification, the government has prescribed Form I. The Form I is an additional requirement which every importer has to prepare whether the verification will be done or the verification will not be done. Although the authorities have mentioned that only on the inquiry Form I has to be prepared and given to the authorities, but in order to avoid delays in your consignment clearance, it is always suggested, and it is suggested by the to the importers that they should have these Form I prepared in advance in order to avoid any kind of delays, as well as to have a better documentation from the exporting country. And then if everything goes verifies, then that is fine. If there is anything which the government authorities, the custom authorities, they want to check over and above, then they will ask the questions, and the importer has to furnish that details within the prescribed time period. So with this, there is an increase in information requirement to substantiate the origin and increased dependence on the global suppliers for the real-time information. These are the two things which has happened from 21st of September. Now the imports which are and the clearance which are being done on or after 21st of September 2020. And in fact, this notification which has prescribed the rules that came on 21st of August, and the government has prescribed almost 1 month period to the importers as well as to the companies to give to prepare that information in advance. So this is something just steps which we highlight, is that every importer, they need to possess the information which is being prescribed in Form I for each shipment. Furnish the additional information while filing the bill of entries. The additional information which we just discussed about is you need to furnish the details of the certificate and other details in the electronic while filing the bill of entry. Then the second step will be initiated during clearance or any time inquiry by the custom authorities. It can be at the time of clearance or even at the time any time within 5 years from the date of import. And then information, as I mentioned, that they are prescribing a very limited days to provide that level of information for each level of SKU items. So the information which is to be prepared in Form I is to be prepared for each and separate SKU items rather than the entire shipping bill. So you need to prepare all that information within the and give to the custom authorities within the time period of 10 days. If the origin criteria met, then claim will be accepted in writing within 15 days. If that will not met and they ask for the further information, then they can verify. They will be verifying the subsequent bill of entries and recommendation will be given. The fourth step is verification from the exporting country. They can also verify from the exporting country within 60 days. Conclusion of verification, they have prescribed it so they have prescribed that what are the days they can do it and how much days they will be the law has given to the custom authorities to verify in order to avoid any procedural delays by the custom authorities and even making the India more exposed not towards ease of doing business. Origin criteria, if the origin criteria does not met, then preference days to be suspended and goods to be cleared on provisional assessment with security till the conclusion. And in fact, if that will happen, then the exporting country which are exporting even is supplying to any other company in India, their preferential rate will also be withdrawn and the benefit will not be denied to that importer for which the verification was not even done. So this was just the ideal. Now this is the basic information which you need to furnish while providing the while filing the bill of entry. Is that first you need to provide the details of treaty of free trade agreement, whether you are if you are importing from Thailand, then you can use the Asian free trade agreement. If you are importing from Japan, there is a free trade agreement. So you need to furnish the details of free trade agreement, providing the details of certificate of origin, the reference number along with date of issuance. Produce the certificate of origin covering each item on which the preference rate of duty is being claimed. Then you need to furnish electronic. So these all information need to be submitted electronically while filing the bill of entry. The origin criteria is first whether wholly obtained or not wholly obtained. We'll discuss in detail what is wholly obtained, what is not wholly obtained. If that is not wholly obtained, then whether the general rule or product specific rule. So I will be discussing about that what is that how you can derive whether it is wholly obtained, how you can derive it is not wholly obtained, because for each thing you need to actually check the free trade agreements. And in fact in a circular as well it has been written that free trade agreement conditions will overrule. So wherever there is a if in general there are three conditions which are always prescribed in any of the free trade agreement. One is value addition norm, wherein generally standard value addition norm is 35%. So you need to compute the value addition. There is a formula which is being prescribed under each free trade agreement, that how you need to compute the value addition norm. Second criteria which generally need to prescribe under each free trade agreement is change in tariff heading classification. So if there is any non-origin goods, so non-origin goods are required to go in a tariff heading change in the final products. So whether the non-originating goods has gone to the tariff heading changes as well. And the third important criteria is whether the final manufacturing process was done into the exporting country from which we are obtaining the benefit of country of origin. Indicate if accumulation or accumulation is applied. Generally it is no. We'll discuss that accumulation and accumulation. What is that accumulation or accumulation? So I'll give the brief detail that there are certain free trade agreement wherein it has been mentioned that even though the goods are not being used from that origin country, but there are other countries from which the goods were produced. So that means that if there are 3 countries which are prescribed under that free trade agreement, if the goods are produced or used for manufacturing are from other countries, that will also satisfy the procedure of wholly obtained or origin criteria. We'll discuss the practical aspect, and then indicate if the country of origin is issued by a third country. So generally we need to also see, and that is one of the requirement in the free trade agreement as well, notification, that whether the exporting has been done from the same country wherein the country of origin benefit is being claimed. Then you need to see so now this is the information. So there are 2, one is that wholly obtained goods and one is not wholly obtained. So we have prepared an annexure which needs to be filled for your so that is one. First we'll open the form I. Is the form visible? Is the form visible to everyone? Vishaka, can you tell, is the form visible? Hello?
We can only see the PPT. We can't see
Hello?
the...
Vishaka, is the form visible?
No, sir.
Okay. Just let me. So this is form I, which has to be prepared by the importer. So if you see this form I, the first step is that you need to furnish the name of the importer with address, with contact, exporter name and address, custom station at which the custom station, name of the product as per invoice, general description. And then you need to furnish certain details of the items. So first item is, so if you are importing a SKU, so you need to furnish the details of that SKU and then the description and then the classification of that description. What is the 8-digit classification which is being prescribed? Then you need to furnish the details of, if let's suppose you are importing a mobile phone, and that mobile phone constitutes of 5 originating and 3 non-originating material. So you need to furnish the details of all those, what are the components which are being used in that mobile phone manufacturing, and what is the component which are being used in the mobile phone and which are originating criteria which are being used and produced from that country itself, from where the country of origin. So if we have imported from Thailand, then whether all these 5 components which were used in the manufacturing of mobile phones are from Thailand. So you need to prepare, you need to furnish the SKU details, mobile phone in each 1 to 3 items, HSN of that detail, then description of that 5 each item which were originating. And then you need to furnish whether that manufacturing was being done. So there are 3 questions for each particular. First question is whether the manufacturing or by the producer of the final product. So if your exporter has produced that, so there are certain exporters which produce the intermediate goods and use it in the final product. So whether that exporter itself has produced it, if yes, then mention. If no, then you need whether you have procured from a localized third party. So if your exporter has taken up from the third party and that third party, then you need to furnish yes. And the third important fact which you need to furnish is, in case the third party if that product were obtained from a third party, whether it has produced within the country or it was obtained from some other country. If they have produced within by the said vendor, then what is the documentary proof you are taking to confirm whether that the production and manufacturing was done by the third party within that country from where the country of origin is being obtained. So these are the information which is subdivided into the material level of that product which were used in manufacturing of the final product. So final product, if mobile phone, and what are the components which are being used, and among that component what were the originating from that country itself. You need to prepare these details in respect of that. So this is very important because you need to furnish if you are taking it from a third party and you do not have documents to substantiate that whether they were being produced from that country itself, then it will be assumed that it is also non-originating, and while computing the value addition norm, you will not be able to take the computation, you will not be able to take the value of those component in arriving out the value addition percentage. So this is one of the important point while preparing the Form I. So Form I has to be prepared for each of the SKU items which are being imported. So it has to be prepared. So if you will see this, so we have specifically mentioned that this declaration has to be obtained by the importer in respect of each SKU items on which the preferential rate of duty, even if one consignment, a bill of entry has several SKU items. So you need to prepare that this form for each SKU items rather than for the entire bill of entry. So then for that mobile phone, so if we have taken an example of mobile phone, so this is the description of that mobile phone you need to, and then you need to mention that what is the production process, what is the production process which is being involved, and then you need to mention that what is the originating criteria. So generally what I already discussed is that originating criteria are generally of the three conditions. One is RVC, which is regional value content. The second is non-originating material must have undergone at least a change in tariff heading level, at least 6 digit of a harmonized, and the third final process of manufacture is performed within the country of the exporting. And then this is one of the questionnaire which you need to furnish while preparing. So this, before this questionnaire, so one first important question is what is the name of the preferential trade agreement. So if your preferential trade agreement is Asian Free Trade, so you will mention Asian Free Trade Agreement and declare the name of the preferential trade agreement you wish to clear. Second question is which you need to, whether the goods are wholly obtained. If you will say no, then whether you need to go to the third question, whether goods not wholly obtained. If it is not wholly obtained, so it means that then you need to furnish the details in point number 4, 5, 6. The point number 4 is the originating criteria based upon value content. So for this you need to see is whether the originating criteria is whether the originating criteria is based upon the value addition. So value addition is so value addition norm has to be computed based upon the each of the country of origin and the notification. So if you have imported from Japan, then there is a formula which is being prescribed in the treaty and the notification. We'll discuss with one of the instance as well. Second, you need to see and you need to provide two important information. What is the percentage of local value content and a component which constitute second has the CTC, the custom tariff heading rule has been applied. So custom tariff rule heading for meeting the originating criteria means if a non-originating criteria has gone to a change in tariff heading in the final product. Sixth point, has the process rule being applied in ascertaining? If yes, then provide the rule which is to be. So in certain free trade agreement, there is a process rule. If that rule is to be seen, then in certain free trade agreement, de minimis provision used to determine whether the goods subject to this request qualifies as originating. Some agreements have a de minimis, we need to refer the agreement, but it is being clearly mentioned even in the notification and the circular issued that if a free trade agreement, the conditions which are prescribed in the free trade agreement only has to be seen rather than any condition. So you do not need to see each and every de minimis or any other. If that has been prescribed under the free trade agreement, then only you need to see that. So similarly, there is in some of the free trade agreement are accumulation and cumulation provision. Accumulation and accumulation provisions allow the countries which are part of preference free trade agreement to share a production process in case jointly comply with the relevant rules. Then we need to refer the free trade agreement. The ninth important question is, has any other criteria such as indirect, neutral, packing material used in ascertaining whether the goods qualify as an. So indirect material are referred to as energy, fuel, plant, machinery, or machine tools which are used in the manufacturing of the said product. Depending upon the agreement, it may qualify as originating and non-originating. If yes, then we need to. The last, which is important point is, has the consignment in question directly shipped from the country of origin? If your shipment is coming, let's suppose from Dubai, and the country of origin is, let's suppose, you can say from the Asian, the country of origin is Thailand, then you need to see that most of the agreement lays down the condition that goods claiming originating status of a country should be directly transported from that country to the importing country. So certain relaxations are provided in trade agreements. So you need to see that as well, because if this condition does not satisfy, so even you do not need to see the other conditions, because if the free trade agreement is specifically talking about that it cannot, it will not give any benefit if it is being shipped from a third country, although the certificate of origin is there, then you will not be able to avail the benefit out of it. So has the country of origin being issued retrospectively? So if yes, then we need to provide the details, and this has to be filed by the importer as well. So practically we have been told that although this information was required to be submitted only at the time of verification, but there are certain customer points which are asking to furnish this detail in advance as a declaration by the importer and the importer also need to obtain this specific form signed from the exporter as well. So these two are the important things which needs to be seen. We have also prepared one sample Excel sheet wherein we can talk about that how that free trade agreement needs to be seen for any of the imports. So we have prepared this Excel template for the purpose of each and every SKU items. So let's suppose if we are importing from Thailand and Vietnam, which is a Asian free trade agreement, or a Japan. So first of all, we need to furnish the description of the SKU items imported on which FTA is being claimed. We need to provide the details of that SKU which is being imported. Then of that SKU items, we need to decode what is the production process which is being involved. Then we need to furnish the details of originating criteria, that what is the value. Is the originating criteria based upon value content? So that we need to furnish the details of value content. Then we need to see what is the originating, when the value content is being used, that what is the steps which are being used for the value content. For the Asian free trade agreement, we have prepared the steps. So first step is whether the country of origin and port of landing are same. If the answer, if yes, then proceed to step number 4. So whether the country and provisions are same, then we need to go to the step number 4. Now, if it is no, then we need to check whether the case falls under any of the following conditions. The following shall be considered as consigned directly from the exporting if the products are transported passing through the territory or any other FTA countries. So these are the conditions which are being prescribed, even if it is coming from other port. So if the country of origin and port of landing, the loading are same, or if they are not same, then we need to see this. If they are same, then we need to go to step number 4. The step number 4 talks about that whether the products are wholly obtained or not wholly obtained. To check whether they are wholly obtained, you need to check the 5th step. The 5th step talks about the meaning of wholly obtained is defined as goods should be produced or obtained without any originating input material incorporated. So this is being given in the free trade agreement itself, the definition. If the answer is no, then check the criteria for not wholly obtained or obtained products that are provided in the free trade agreement. The sixth step is check the relevant free trade agreement and its criteria to determine the formula for evaluating the originating. So seventh step, notification relevant for that FTA. The eighth step is the conditions. So in the Asian Free Trade Agreement, 3 conditions are being prescribed. The first condition is how to determine the value. The value addition norm should be, there are 2 methods. One is direct method and one is indirect method. So if a direct method, then what is the formula? IFTA material cost. IFTA material cost is Asian Free Trade Agreement material, whosoever are originating from that country, Thailand, then that has to be taken. Then the direct labor cost, direct overhead cost, other costs, profits, and all these must be over and above the 35. So minimum percentage which has to be achieved is 35%. The second condition is that non-originating material must have gone at least a change in tariff heading 6 digit. And the third condition is the final process of manufacture is performed with the territory. So, so first we have defined that originating criteria. Then we mentioned that you need to go to the step condition number originating, how to compute the IFTA material cost divided by FOB price. Then you need to, the second important aspect is value content. What is the value content? That value content is being prescribed. Then whether your non-originating material is going in a change in tariff heading, yes or no. If yes, then provide the HSN of the non-originating material used in the production process. If yes, so if the procurement of the raw material which were used in final process has gone in a change in tariff heading, then you need to provide the HSN of the non-originating, and because the final product HSN is clearly provided. Has the consignment and quotient being directly shipped from the country? If yes, if no, then check the conditions which we have covered in the free trade. So this is how you go and check each of the free trade agreement, each of the consignment on which the certificate region or the country of region benefit has been taken. So let's go back to our presentation. So this is what we have prepared in the templates form, the kind of documentation which we need to. What is important is that in each kind of you need to prepare that what is the originating criteria, originating material which were used in the production process, and how that has been, how you will substantiate whether these were the originating from that country itself. So a proper robust documentation has to be obtained. A proper indemnity from the exporter has to be obtained, so that in case any benefit is denied or any exemption is denied, even for a period after the period of clearance up to the period of 5 years, then you will be having that level of indemnity from the exporter, specifically from the exporter which are not related party, and you are procuring the same from them first time or for a period. So other important details which needs to be signed is declaration need to be signed by the importer while filing the bill of entry, that I declare that the goods qualify as originating goods for preference rate of duty under customs rules notified from 21st of August. Certificate region should be mandatory defaced. So the port authorities will deface the out of, while doing the out of charge, they will deface the country of origin certificate, so that it cannot be used again by the importer for any other consignment. And all class of importers, including the authorized economic operators. So in India, there is a concept of authorized economic operators which are given certain benefits and relaxations and even for the clearance of the goods without even paying the custom duty in India. And that's a very good concept which Indian custom authorities has brought under the Indian custom law, which every country should explore this kind of options, although there are very minimal information which is being available to various importers in the country, which are required to be furnished by 100%, and they are also required to furnish the 100% differential duty if they are their FTA, if the custom authorities deny the benefit based upon the country of origin. So what is the suggested documentation which we suggest is you need to prepare a complete SOP which we just discussed in a various templates for each of the SKU items in detail before even the custom authorities ask you and for the verification, so that your shipments, your things, and you were not exposed towards the differential liability even today at the time of clearance and even till the period of 5 years. So you need to prepare the right internal process for future and align the overseas vendors or existing overseas vendors with this new kind of rules which has come from 21st of September. And apart from that, it is very important that in all the agreements which are being signed with the overseas vendors, there should be indemnity clause which should be inserted, so that any kind of risk if there tomorrow basis the non-availability of the document or incorrect documents, then the importer can take the benefit by way of that indemnity clause in their agreement. So that's more for the today. If anyone has any query, then we'll be happy to tell, and in case anyone wants to even put a mail, then they can put a mail at our email ID bd@cretamadvisory.com, or you can connect with us directly as well on my email ID kapil@cretamadvisory.com from the point of view of any query. And in case if someone has a query, then they can raise there on a chat box and we'll be happy to give a reply.